the call. I apologize. This is Mike Pendergrass, president of Legacy Planning Partners and Premier Advisors Group. We're having a few technical difficulties this morning trying to get the Zoom webinar to cooperate. So if you're just now coming in and joining us, certainly appreciate your patience. Since we are wanting to be really respectful of your time and appreciate you taking some time out of your day to learn more about this very, very important topic of special needs planning, an area of planning that we see many times overlooked. We kind of want to dive in this morning. And what I would like to do is introduce you to one of my counterparts here at Premier Advisors Group, Mickey Butler, our vice president based out of Tulsa, Oklahoma. Let her tell you just a little bit more about our schedule of events or our agenda this morning and introduce our keynote speaker, Brittany Littleton. So with that, I'm going to turn it over to you, Mickey, and we'll go from there.
Thanks, Mike. I want to welcome all the families and friends that are on the call. And I'd like to congratulate you for taking some of your very precious, dear time to learn about estate planning for loved ones with special needs. And we really appreciate how limited and precious your time is. So we're going to keep this to 45 minutes and we're going to jump right into it. But before we start, I'd like to mention two things. First of all, our hope is that this is going to provide you with some information about recent legislative changes that you may or may not have been aware of. And secondly, and perhaps even more importantly, we want you to know that you are not on this journey alone. You've got people, the financial professional who invited you, Brittany Littleton, people who are here to help you get answers and to understand what is my next step, because it can be overwhelming. And so to the point of questions, I'm going to welcome you to put those in the chat box, and we're going to get to as many of them as time allows at the end. And some of them are probably going to be a little too personal for us to bring up in front of the entire group. So what I want you to know is that we will get you an answer to your question. And it might just be a personal answer and it'll be from, offline. But it's really my honor to introduce our guest speaker today, Brittany Littleton. Brittany is the managing partner of Littleton Legal in Broken Arrow. And we're very honored to be hearing from her. She started out in estate planning, and when she founded Littleton Legal, she decided that she would expand upon the estate planning experience that she had had because she wanted to help individuals and families from all walks of life deal with some of the unexpected things that life throws at you. She's a member of the National Association of Elder Law Attorneys. She's a member of both the Oklahoma State Bar Association and the Tulsa County Bar Association. And Brittany serves on pivotal committees with both of those associations. She's also a board member for the Chamber of Commerce of Broken Arrow and many other things. My favorite thing about Brittany is that she describes herself as a social justice advocate. And that's never been more clear than when she presents these informational seminars to families of special needs. So we're really grateful that she brings us this information today, and I welcome you, Brittany Littleton. Thank you.
Hi, guys. Thank you for having me today. I'm privileged that you're taking some time out of your day to be here with us. Thank you to Mickey and Mike and the teams at Legacy and Premier and Penn Mutual. I love working with you guys, and lots of my clients do too. So thanks for asking me to be here today. I'm going to share my screen. Give me just a second to, there we go. All right. I'm a better lawyer than computer navigator, I promise. So now do you see my my main screen?
Yes, looks great.
Thank you. All right, so today we're going to be talking about estate planning considerations for your loved ones with special needs. And as Mickey mentioned, we want to be really sensitive about your time. So I'm going to jump right in because we have a lot of things to cover today. So the first thing that I want to talk about and just acknowledge really is that the disability community is very diverse. today I want to share my knowledge about the topic of special needs planning, but I also understand that individuals have very different physical, mental, and health needs that will vary based also on your family and financial circumstances. So there's no one size fits all solution, but today, hopefully we'll talk about some general concepts and strategies that are pieces of many plans. I'm going to try to focus on facts relative to all aspects of planning for the quality of life of somebody with special needs. And I'll include information about legal issues, financial issues, and government benefits. But I won't be providing specific legal advice or recommendations related to individuals on the webinar. Estate planning and financial planning should always be unique to your personal circumstances, but especially in a family dynamic where we're planning for a loved one with special needs, it's really critical that your advisor has an in-depth knowledge about your personal circumstances. And if that's a discussion you want to have later, we can certainly do that. But until that makes sense, please, as you're listening, keep in mind that we're talking about general principles and you shouldn't construe it as personal legal advice. Of course, when we talk about the financial planning aspects, if you have questions related to that, a great place to start is talking to the advisor who invited you to this presentation. And then there'll be things that don't fall into legal or financial planning. And if you don't know where to get started with looking for a resource in that question, me or your financial advisor can likely connect you with somebody who can help, and we're happy to do so. So for purposes of today's discussion, I'm going to assume that regardless of what your loved one's special needs are, you're here today because you're seeking answers on how to provide long-term quality life care for your loved one with disabilities. Lifetime care, of course, is important. Everybody has to have their basic needs met. But if you took time out of your busy schedule in the middle of your workday or home day, you're probably thinking beyond survival mode. You're here because you want to talk about how your kids or other family member can live a happy, fulfilling life and have access to resources that will improve their quality of life. As long as we're alive, most of us will do whatever it takes to ensure that our children have everything they need. But the big question is, what will happen when you're gone? Why should your dependents' care be any different if you're gone? And if your child's needs change because you're not here to take care of them, they'll likely have more needs, not less needs. In my work with special need parents, I often hear that what keeps them up at night is this question. They want to know who will take care of their child, what care be provided the same way it is today, and where will the funds come from to ensure that your wants and wishes for your child can really happen. Of course, what you're looking for is answers to those questions, and those answers really lie in proper legal and financial planning. And as we move through this conversation today, hopefully you'll see how these tools really work best when they're utilized together. So if you have done some basic estate planning or financial planning in the past, now might be a good time to review it. First of all, the laws change a lot. We're dealing with new tax laws. We're dealing with an act that went into effect January 1st, 2020 called the Secure Act that has significant changes with regard to retirement planning. The ABLE laws have been updated, but also your personal facts and circumstances change and your goals change. When we talk about estate planning and financial planning, we're thinking proactively, but we're also thinking about what are your needs today. And your needs today are different than they're going to be 5 years from now or 10 years from now or 50 years from now. And so you want to think about this as kind of an ongoing process. Hopefully you'll also learn today that general financial or estate planning can be very different. when you're also planning for a child or family member with special needs. And it can be really important to work with a team of professionals that understands the nuanced issues. Many people with disabilities will need government benefits to supplement their needs. So one question I like to make sure to ask people that I'm working with is if they realize that if they leave assets to their child in an amount over $2,000, then they are likely to cause them to lose eligibility for most government benefits. The details of how the government benefits work can be complicated, and I won't get too deep into the weeds on that today, but I do want to touch on the highlights because it plays into the big picture conversation. I also want to mention, though, that it's a common misconception that special needs planning is only for the impoverished. People assume that if you don't need government assistance, then you don't need to plan, and that's just simply not true. While there's lots of disabilities that don't prevent an individual from having a meaningful employment, but even in those cases, the future can be less certain. Future health complications might be more likely to occur. Higher health costs might be a reality, or there might be limited career options that would make it difficult for your child to accumulate sufficient wealth to plan for their retirement. And there's even if you have unlimited resources, there's always room for planning with regard to asset protection and tax planning. So two of the benefits you're going to hear about most frequently are SSI and Medicaid. And one of the most important things to know about SSI, which is supplemental security income, it's funded by a U.S. government program to provide for the basic needs for the aged, blind, and disabled. And disabled is defined very narrowly for purposes of SSI. And in most states, if you qualify for SSI, you also qualify for Medicaid. And Medicaid is the federal system of health insurance for those requiring financial assistance. But even if you don't think your child will need SSI because they're able to supplement their own income with work, they may very well need Medicaid either always or in the future. So it's still important to understand why you'd want to protect that benefit if they needed to turn it on down the road. Of course, both SSI and Medicaid are needs-based. They're limited in scope, and we see as healthcare costs and long-term care costs skyrocket, the financial industry is playing a bigger and bigger role in providing services that traditionally were provided by the government. And we're going to talk more about those services in a few minutes. But the government dollars, you might be shocked to learn, just don't go nearly as far as they did a generation back. So let's take a step back to talk about the basic legal considerations. So everybody needs an estate plan, regardless of whether they have a child with special needs or not. And an estate plan is really the legal tools and plan that you have in place to talk about what would happen to you and your assets if you became incapacitated and upon your death. If you don't have a plan, the state has one for you. And it's probably not what you'd expect or what you'd want, but that's how people wind up in probate court, in what's called an intestate proceeding. That's the law. That's the legal word that means you passed away without a will. And typically when parents tell me that they haven't completed their estate plan, they say it's because they can't decide how to distribute their assets or who to appoint as guardian for their child. But I like to encourage them that the worst decision you could make would probably most likely still be a better choice than one made by a random judge who knows nothing about you or your children. So lean on your attorney, your financial advisor, your other professional resources to have a conversation about what are the scope of options available to you, because often they can help ask questions that will lead you down a path that makes it more clear who should be in what role. When we talk about estate plans, they usually fall into two broad categories for foundational planning. One is a will-based plan, and what a will really is a letter to your family and to a probate judge that explains who gets what part of your stuff when you're gone. It appoints a personal representative or an executor to carry out the instructions. And often, and hopefully if you have minor children, it also mentions who you would want to be the guardian of your child upon your death. A trust, and here there's lots of kinds of trusts. So here I'm talking about a revocable living trust, provides for the orderly management and distribution of your assets upon your incapacity or death, but without court interference. It's less burdensome to your family. It's private instead of public. It's less likely to create family conflict, and it's typically less expensive to administer upon your death and offers much more planning opportunities. In a trust, you appoint a trustee as the decision maker, and that person is usually somebody who has the ability to manage your money well. That's a very basic overview, but just know that those are kind of the foundations of basic estate planning. Which one is right for you depends on your circumstances and is a more in-depth conversation. Another thing that's really important to families with minor children or who have a loved one with a special needs is the idea of guardianship and conservatorship. So beyond nominating a personal representative and a trustee, if you have a minor child, you also need to consider who would serve as their guardian if you can't take care of them. This is true for all parents, but it's especially important conversation for parents with children who will require lifetime care. When your child's under the age of 18, you as his or her parent are the legal guardian unless a court has taken away your rights. But what that basically means is that you make all decisions for your child until they become a legal adult. And the law says that happens at age 18, regardless of their ability to actually function as an adult. So if you have a 20-year-old child who lives at home with you, you provide round-the-clock care and 100% financial support, and they have a functional age of 12 because of their special need, then that child is still considered a legal adult. And you as their parent must apply for guardianship through a court in order to have control and responsibility over your adult child with a disability. But the other thing that you have to think about is what would happen if you weren't here or able to care for your child. That's when you would appoint a guardian other than you to watch over your child. And I highly recommend that you make your wishes known now in a formal written document. And that's a will for upon your death and a durable power of attorney in the event of your incapacity. You might want to consult with family members, but you'll want to be sure to choose the person who you believe would be best able to care for the child. And after you die, or when you can no longer care for your child, the person that you designate will go to the court and file an acceptance to an appointment to be your child's guardian. And unless there's a very valid objection, your wishes will be honored instead of the court picking whoever files first or making an arbitrary decision. Just a side note, it might make sense to appoint a different person as the trustee or personal representative than the guardian. The thought there is that the trustee is a person that's going to think with their head about finances, and the guardian is going to be the person thinking with their heart about what your child's day-to-day needs are. For example, you probably wouldn't worry that your mom will run away with your money, and you know that she might love your child, but does that mean she's a good money manager? And again, that's a conversation that you'd want to have in depth with your attorney or your advisor as you're putting together a formal plan. So when people are overwhelmed by their choices or they don't understand what estate planning tools are available to them, often the easiest course of action is to do nothing. Second to that would be to kind of piecemeal a do-it-yourself plan or a homemade estate plan. And especially in that kind of do-it-yourself arena, we see a lot of common mistakes. Some families think that it's in the best interest of their child with special needs because of that $2,000 rule that we talked about earlier to disinherit that child. Instead, they'll leave all the assets to siblings or family members and just give them, verbal instructions or hope that they'll use the funds to care for the child with special needs. But there's no guarantee that the funds will be used for the person's care and support. Even for reasons outside of the family member you trusted's control. Those assets could be attached by lawsuits, divorce, legal judgments, or just spent inappropriately. Also, you're counting on that person surviving your loved one with special needs and also having done their own legal planning to make sure that that asset doesn't become subject to their probate. It can happen on the flip side. Well-intentioned relatives could leave assets in their estate plan to your child. Your generous aunt names your child with special needs as the heir of her estate without any additional planning. And because she's done that, it's caused your child to lose benefits, their eligibility for government benefits. So what better options are there that you should be considering? The best and really only solution is a special needs trust. And the special needs trust accomplishes two primary functions. It protects government benefits from eligibility, and it provides a way to create a quality of life for your child. It not only protects their SSI income, which provides for their basic needs, but it also protects Medicaid, which can provide for the things other than food, clothing, and shelter. The assets owned by a special needs trust are meant to supplement, not replace government benefits. So you're widening the pot that's available to provide that quality of care to your child. This is really the difference between focusing on that lifetime care versus the quality of care. But of course, in order to provide all those wonderful things, the trust needs to be funded. And that's what we're going to be talking about next. Because of time, I'm going to just really gloss over these, but we can send you a printout of the slides so that you have it in more detail. But there are many types of trust, and there's actually even several types of special needs trust. But what I'm talking about today is a third-party special needs trust. From this chart, you can see that there's no limit to how much money it can hold, and it can be funded by anybody. There's another type of special needs trust called a self-settled trust, and those have payback provisions, meaning if anything's left and you receive government benefits, you have to pay back upon the death of the person with special needs. That's not what we're talking about today. That's another deeper discussion for another day. The other thing to note is the qualified expenses for a special needs trust. One of the most common questions I get asked is, what can my special needs trust pay for? The answer there, to really oversimplify it, is everything but food and shelter. That's what's covered in your SSI income. And this asterisk here on to purchase a home or pay rent, that means there's a variety of qualifications that have to happen in order for a special needs trust to be able to provide for a home. We frequently have real estate owned by a special needs trust, but if it's not drafted properly, it can create problems with government benefits down the road. But the reason why there's that asterisk is because there are some caveats to when this is a yes. Another opportunity to provide financially for your child is with an ABLE account. And the ABLE Act stands for Achieving a Better Life Experience. It was a law that went into effect in 2014, and it allows qualified individuals with a disability to have a tax-free savings account. If you're familiar with a 529 account, it's very similar to that. And it's definitely a good foundational tool to consider funding. However, it's more limited than a special needs trust. So often it's a one component in a bigger plan. Some of the limits that an ABLE account has is that it only applies to disabilities that are onset before age 26, and you can only gift up to $15,000 per year to it. That $15,000 is tied to what the annual gift tax exclusion in any given year is. And so it does vary a little bit from year to year, but right now it's $15,000. Also, the account cannot exceed $100,000 in total value without impacting SSI benefits. But under the new final rules, it doesn't impact Medicaid. And your child can only have one ABLE account, and there are some payback provisions. The new rules that just went into effect, they were actually published last month, do allow people with disabilities who are employed to deposit some earnings in an ABLE account so that you can contribute above and beyond that $15,000 up to the value of the poverty line in the state where you live. And we're going to share an article in our follow-up after this presentation that goes into a lot more details about the final rules for the ABLE accounts. So now that we've had kind of a general discussion of the legal issues, I want to turn our attention to the financial issues. And the special needs trust that we've talked about, you can create it and fund it now so that your child can have their supplemental needs met without compromising government benefits and without interruption in case something happens to you. But a special needs trust is only as good as the assets inside it. So if you never fund it, it's not very helpful. So we're going to talk about the sources of funding and the type of funding, and we'll touch on if we have.
Brittany, real quick, I'm so sorry to interrupt. It looks like there might be a pop-up on the screen that is.
Thank you.
Thanks. You can go ahead.
Do you guys see my webinar videos too? Sorry about that. Okay. So next we're going to talk about how to fund a special needs trust. So the 5 primary sources of funds are the child through their earnings or gifts to them, also parents, grandparents, and siblings, and then the government. So things are usually given, saved, or acquired. For purposes of today's presentation, though, we're focusing, I'm assuming that the participants are primarily parents. If you're not a parent, just know that when I say the word parent, it really can be anybody that's in this role. So there are 4 basic funding vehicles. We see real property, investments, retirement funds, and life insurance. The first funding option with regard to real estate is your home. So a lot of the times my clients will say when they pass away, they want their home to be sold and the proceeds to go to the special needs trust. But the problem there is that your child's needs might be immediate, and real estate is not a liquid asset, and it's difficult to know what its value will be at the time of your death. Next are non-qualified investments such as mutual funds, stocks, and bonds. And these certainly can play a role in an investment plan. But again, the economic climate will determine how much really ends up in the trust. So you have to ask yourself the question if you have enough time in your time horizon to save enough money. Also, many folks say that when they die, they want their qualified investments, which would be your retirement accounts, your 401k, your IRA, to fund the trust. But we don't know how old you'll be when we die. And if you die prematurely, will you have contributed enough to your retirement account? If you live a long, full life, which we hope for, will you have spent down a lot of your money? We also have to think about the tax consequences of that. So when you're planning for both your retirement, maybe your spouse's retirement, and also the long-term care of your child that you might be providing for well into their adulthood, that's really a 3-person retirement that you're planning for. So you want to make sure that you're having the conversation about what's enough and what's your strategy. And then probably the most common funding source is life insurance. And really there, the risk is, not having any. We're going to talk more about that next. So there's lots of types of life insurance, and it can be difficult to know what type is best for funding a special needs trust. But, the answer is it depends on your circumstances. Many people really don't know what type of insurance they have, or if it's best for their situation. So this is a great question to reach out to your advisor on. I'm going to just touch real briefly on a couple of different types. And I'll keep it basic. But first, there's term, and term is temporary. It's often less expensive than permanent, especially if you're young and in good health, but it does get more expensive as you age. A lot of people think that they're covered on the life insurance front because they have a group policy with their work. But keep in mind that if your job changes, that insurance changes. And if you have to replace it, it might be much more expensive, or you might not have the health that you need to qualify for it down the road. There's also whole life insurance, and whole life insurance is a permanent, simple lifetime protection. It's more expensive than term typically, but it provides lifetime coverage for a guaranteed price with a guaranteed death benefit and often a cash value. And there's also universal life. Universal life can be permanent. It has flexible premium payments, and it has a guaranteed interest crediting rate as a potential for additional cash value. Many people are able to adjust coverage and premiums as their financial situation changes, depending on health and subject to certain limitations that you'd want to talk about with your insurance agent or financial advisor. A popular option with special needs trust is what's called a survivorship life insurance policy. And that's when we have life insurance that insures the life of 2 people, usually a husband and a wife. And it typically costs less than insuring each of them separately. But it pays at the second person to die, generally in a special needs situation when the funds are needed most, because there's not that other parent alive to basically do whatever it takes to figure out how to take care of their child. And again, this is very basic information, so your life insurance needs should be explored in further detail with somebody who's an expert in that area. But the question is, how much money is needed? And for time, I'm not going to go into how to calculate this, but just know that only you, in partnership with your special needs focused financial professional, can truly determine the right amount. But you'll have to think about what are the annual expenses that your loved one would need. How can we create a return on that initial investment to supplement those annual expenses so that we can protect the principal generated by the life insurance benefit and make sure that that stretches out as long as possible. So at the start of today's session, I stated that special needs really involves 2 critical components, one from a legal standpoint and the other from a financial standpoint. And they're both equally important and really can only work how they're intended to if you're thinking about both of them together. When it comes to that, building the right support team is critical. And because you want to make sure, and I really don't mean this as a self-serving statement, and I think all of the advisors that are on this call would agree. What makes the most sense is that you're working with somebody who you trust and who works well for you and your family. But it is really critical that you are asking and expecting that your advisors are willing to collaborate on your behalf with other experts, and that they have a nuanced understanding of the unique factors that come into play when you have a family member with special needs. Good intentioned advisors, both on the legal or financial side, might not understand where their blind spots are. And so as an advocate for your child, you're going to want to ask questions to know that to have confidence in whether or not they have qualifications to really serve your family best. And one last thing, and this is not really legal advice or financial advice, but this is something that I've seen serve the families that I work with really well. And that's the idea of drafting a letter of intent. And this is not a legal document, but it can be still very important. It's a letter that you write to your child's guardian with all the information that he or she would need to properly care for your child. And in doing so, also carry out your wishes. And for many clients, it's a very difficult thing to do. It can be emotionally draining because you're literally looking far into your child's future as if you were gone. And you're mapping out your wishes, not only for a day in the life of them without you, but also their every day of their life. And it's difficult to do this in a will or trust or financial plan. You'd want to update that letter on a regular basis and when information changes. And you probably want to sign it and date it just to give guidance to your guardian. And then I recommend that once you've completed it, that you share it with the person that you have in mind with the guardian to act as the guardian, so that they truly understand what you're asking of them and can agree that they're up to the task. Because if they're not, then it's probably better for you to know that now while you can still make a change. So really that is all I have today. I know that was a little bit of a whirlwind. Thank you for bearing with me with some of my PowerPoint technical difficulties and Zoom technical difficulties. If there's any questions, I'm happy to answer them.
Thank you so much, Brittany. And, you know, the thing that I take away from your remarks is that there are some minefields out there, and a misstep can cause your loved one to lose their health insurance. And so the one baby step that I might recommend that people do is review your beneficiary designations. You don't think when you're in the HR department on your first day of work that you're creating an estate plan, but you are. And so take out every single beneficiary designation and please have it reviewed. Brittany, can you speak to the different types of trusts and how those might respond differently to the distribution of retirement assets, please?
So, well, that's kind of a big question. Do you mean the different types of special needs trusts? So there are what's called a third-party special needs trust, and that means it's funded by somebody other than the person with special needs. So often, especially in a situation where an individual with disabilities can earn their own income, or maybe they're disabled as a result of a accident or illness that results in a legal settlement. There we often have what's called self-settled trust. And that's when the individual contributes their own assets to the trust. They're still able to qualify for Medicaid to have access to healthcare supplement, but at the end of their life, anything that's left over, it goes back to the government. And it's limited in how you can use that. There's also a type of trust related to Medicaid qualification that it's called in Oklahoma a Miller Trust or an income trust, and it really is a flow through vehicle for people that are in nursing home care to qualify for that. You know, when we talk about foundational estate planning, we're usually talking about a revocable living trust. But we also have other types of asset protection, irrevocable trust. A third-party special needs trust is one of those. One of the components that is really important, and lots of my clients that had been really proactive in estate planning are having to go in and make changes because of the Secure Act. And the Secure Act that we talked about is basically a change in the law that forces retirement benefits to be paid out over 10 years instead of over the lifetime when to a third party. So it's literally the largest death tax on the middle class and upper middle class in modern history, because it starts at $0 and on day one, unless you're a minor or you are within 10 years of the deceased person in age, or you have special needs. So there's a lot of room for planning to pour that retirement proceeds through a special needs trust so that the balance can both accumulate and have asset protection, but also it can be stretched out over the lifetime of the person with the qualifying person with special needs. So if you have multiple children, there's now room for planning in which asset goes into which bucket to provide for the legacy of your children, because the tax ramifications could be really different depending on who the child was. I'm not sure if I answered your question or not, Mickey, but
Thank you, you did. It's very confusing, isn't it? And that Secure Act was a sleepy little legislation passed in December when none of us were looking. And it changed. I think the intent was good, to give disabled persons a lifetime income, but but trusts are treated in two different ways. So if you have a trust as a beneficiary, they really need to be reviewed by an attorney. And you know, the one thing that we want you to know is that you do not have to do this alone. It's complicated. There are a lot of different minefields. And we've had another question pop up in the chat box about 529 plans and the ABLE account. So Brittany, would you like to speak from a tax perspective, how the ABLE account and the 529 plans are similar and how they're different, please?
Well,
question.
Sorry, I just spent last night reviewing the final rules, so I'm trying to make sure I don't speak on anything that has been different since those new rules were released. But you can, actually, I might direct part of that back to you, Mickey. Is there a limit like with the 529 as there is with the ABLE account?
Sure. So yes, there are limits on the 529, but what is different is that it grows tax-free, the 529, if you use it properly. But what was clarified last month is that a 529 plan can now be rolled over into an ABLE account. And so my understanding of the ABLE account is that it would be more liberal in the distribution that you could have from it. So any special needs person who has a 529, one thing you want to consider would be rolling that over into your ABLE account. And then if that individual is actually funding their own account, then they might qualify for the Savers tax credit. So those are good questions to bring up with your financial professional.
And also, you know, often we're incorporating your tax professional as well, your CPA or your accountant, to run those scenarios. I tend to get in a little bit of hot water if I talk too much about the tax implications of things. But you know, your financial advisor, your accountant, and your attorney, really you're going to get the best plan if they're working together and contributing their own aspect of expertise to the conversation.
Thank you. Thank you. And Lisa, we'll get you some more information in writing. So were there any other questions that people would like to enter into the chat box? Okay. Well, Brittany, I'd like to thank you on behalf of everyone. You've given us a lot to think about. This is very valuable. And again, the one thing that we want to make sure that everyone knows is that you do not have to do this alone and that we're here to help you. So please expect to hear from the person who invited you to the event. We're going to provide you some resources and materials, including this deck slide and maybe an article about the changes to the ABLE account, so that you've got some things in your arsenal and you've got a touch point for questions as you move forward and review things. And on that note, thank you, panelists. Thank you, Brittany, and thank you, everyone, for your time today.
Thank
Bye.
you.